All right, morning everyone. I'd like to call the meeting of the Town Zoning Appeals Board to order. First we'll start with a roll call and establish a quorum.
Laura Weigand, present.
Pete Bauman.
Bill Murphy. All right, we do have a quorum, so if you would all stand and accompany with the pledge of allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first thing we'd like to do is review and approve the minutes from the May 9th meeting. Has everyone had an opportunity to look at those? Or?
Yes.
All right, can we get a motion to approve?
So moved.
Second.
All in favor?
Aye.
Aye. Okay, minutes are approved. All right, the next thing we need to deal with is the agenda, adoption of our agenda for today. Get a motion for that, please.
Motion for approval?
Second.
All in favor?
Aye.
Aye.
We're approved. All right, so we have some old business to take care of this morning. It's a continuation of the Elam's appeal, the zoning administrator's decision regarding denial of a fence application for 214 Washington Avenue. As I think everyone knows, we tabled that at our April meeting to allow more time for more information to come in and more discussion before we made a decision. We won't be having a public hearing on that today because we did that in April. So members of the public were heard from in April. However, what we will do, Ms. Nunes has asked for the public record to include the 3 additional documents that were submitted by the attorneys for the Elam and the Howard families. So that will all be included in the public record. Also, she's requested to present an additional staff report which will be allowed, after which the attorney for the Elams will be allowed to make any comments if she desires. All right. One thing now before we begin that I'd like to make clear, and this has been said several times and it's been brought out in the attorney's documentation, this board is here only to decide on the zoning administrator's ruling based on the information presented to us. We are not here, nor are we allowed or capable or empowered to make any decision regarding what legally defines an alley, what legally establishes an alley, who it legally belongs to, or anything of that matter. Those are matters that are better taken care of by the town or even the courts. We are only here to give our opinion as to the correctness of her decision. So, having said that, as long as everyone understands that, Katie?
Sure. So yes, I did do an updated staff report with the information that we have gleaned since your hearing on April 11th. Again, as you've indicated, yes, the Code of Virginia, Section 15.2-2309, contains the powers and duties of the Board of Zoning Appeals, specifically relative to the decision on such appeal, which this is, which is an appeal of an administrative order that was from me. Your judgment is the board's judgment of whether the administrative officer was correct, and the determination of the administrative officer shall be presumed to be correct. At a hearing on an appeal, the administrative officer shall explain the basis for their determination, after which the appellant has the burden of proof to rebut such presumption of correctness by preponderance of the evidence. The board shall consider any applicable ordinances, laws, and regulations in making its decision. So again, it is set in state law as to how you are governing this hearing and making your decisions moving forward. I think it was important to note that during the public hearing, it was raised and submitted as evidence during the public hearing that there is a town code regarding the acceptance of public alleys, section 62.3, which states the following. The findings of fact: there are throughout the town several alleyways which have been used by the town for providing services to the citizens of the town. 2, these several alleyways are platted and dedicated as public on certain plats recorded among the land records. 3, the town has never formally accepted such dedication. And B, acceptance, therefore the town does hereby accept the platted and dedicated public alleyways as public alleyways. And said ordinance was adopted on June 15th, 1987 by the Cape Charles Town Council. So with that information that came in through the public hearing, I spoke with our town manager and had some consultation with town council. And basically, I needed to factor in the public ordinance that had been adopted by town council concerning alleys, and I had not done that when I made my initial consideration of this application. I was only looking at the zoning ordinance, which I felt was the parameters of my job and what I was supposed to interpret and administer. So with that said, every documentation has been provided in this particular case between, oh good grief, Pine Street and Strawberry Street relative to the alley. We acknowledge there's an alley there, I think of some magnitude. Whether it's public, no. I don't think any evidence has been forthcoming at the hearing itself, nor in the supplementary documents that I'm going to ask that you also submit into the record as well, that show that that is a public alley under the definition of the town code. Again, that was adopted in 1987. There's not one document that I've located that references any of those as public alleys anywhere in that stretch of block. So with that said, we cannot consider that a public alley in the purposes of our zoning ordinance, and so therefore I cannot hold any provisions associated with staying away from the public alley, because there is no public alley over there. There may be a private alley, and there may be legal rights associated with that private alley that would prevent development, but that's not for the town to enforce. That is a civil matter that would have to be adjudicated in the circuit court. So with that said, I do want to really stress that this is an issue that is probably not going to be the first time we see this, nor the last time we see this. I think there are other alleys that have been percolating as conversation issues and how we have been administering them. So I think this will be an issue that will continue to be monitored, and policy within the town perspective will need to be examined as to how we have this written both in town code and in zoning ordinance, and how we administer this moving forward. With that said, as I mentioned, we have a letter from Attorney Drake regarding the Elam letter to the BZA, read the appeal. It's dated 6/5/2023 with exhibits, and that was a total of 8 pages that we were asking that be admitted into the record. In addition, there is a letter from Attorney Eason, who's been hired by the Howards, who are property owners in this block of property. That again was dated May 26, 2023. It's a cover letter of 5 pages and has reference exhibits that total 165 pages. We would like that admitted into the record. And then lastly, they did a title opinion that came in from Jeffrey B. Hamaker, dated June 2nd, 2023. It is a limited certification of title that we have asked for that also to be admitted into the record. And so with that said, I will go ahead and provide you my recommendation if that's what you would like to hear at this point.
Yes.
Okay. So again, based upon all this information, we do feel that my decision, I am now telling you I think my decision was an error based upon the consideration of the town code section, which again defines public alleys as the acceptance of the platted and dedicated public alleyways as public alleyways. And there is no evidence that the alley from Pine Street to Strawberry Street between Washington and Jefferson has been platted and dedicated as a public alley, and the information provided in the briefs from Attorney Drake and Eason do not show that this is a public alley. So therefore, I have proposed a motion for your consideration, and that is before you in the staff report, but I open that for your conversation and deliberation at this point in time.
Okay. Ms. Drake, do you have any comments you'd like to add?
Yes, thank you. Good morning, everybody. Thank you.
Morning.
I just wanted to stress that part of the record that we've submitted, that record is really establishing that there is not a public alley. The record is actually establishing the fact that there is no private alley because the person who was purportedly creating these easements, or who was inserting the language into the deeds in 1920s, had not actually owned all of the land over which he purportedly was granting an easement. And as you know, and I think this is just intuitive, you cannot create make spring into existence property interest or convey interest in property when you don't own that property. And therefore, when the Scott Trust was placing that language into the deed, the reason why they included the conditional consent language was because they already knew that they had conveyed some lots away from that subdivision, and they had not reserved any easement in those deeds, which are commonly known as the consent lots, and therefore they could not possibly legally create the easement as they had written it as a suggestion or a possibility for the future in the deed. They simply didn't have the legal right. And so this easement never sprang into existence, so to speak, public or private. It just is a legal impossibility for it to exist. And Mr. Eason and the title company had established that there is no record in the years from 1884 until today, no record showing any recorded consent to an easement, which, by the way, it would not take only the consent, it would also take the approval of all of the other lots that had been already conveyed. All of the people that live alongside that easement, they would all have to agree, along with the consent lots, they would all have to essentially make an instrument that would create this easement by agreement now. The other option by which they could do that would be if somebody bought up all of the lots and they could re-subdivide it or they could replat it and create this interest and create this easement by a plat, perhaps. But there was no unity of title at the time. I had discussed this with you previously. There was no unity of title at the time when, in 1920s, the easement was mentioned for the first time and inserted into a deed. And therefore, it does not really exist legally. The other matter that I wanted to bring to your attention and ask for your consideration is that Mr. Elam had gone through quite a journey in trying to get an approval for his application. There had been significant delay and significant expense in trying to establish that, which is actually in your code already, that shows that for the purposes of the town code and the zoning code, the town would simply not take jurisdiction over this in the manner that it was done. There was also some irregularity with the fact that during the time when his application was pending, he had to wait for about 8 months, I think, to get his reply, but to get his denial. But also, there were other properties that had received approvals during that time for similar kind of activity that was blocking the supposed alley, which was the ground for his denial. There was even an application that was recommended for approval after Mr. Elam, and during the time when Mr. Elam was, receiving his denial. After him, another person had obtained their approval. Certainly, there is some irregularity with regards to handling his application, and so I would like to submit a request to you for consideration to reimburse some of his costs of having to establish that which seemed evident previously, and having had to gone through all this process, which we think was not completely necessary. So just wanted to say that for your consideration. I'm not sure if Mr. Elam wanted to add anything? Yes. Okay, he just wanted to add something. Is that okay with you? Yes. Thank you, sir.
Good morning. Morning. I just wanted to say, I'm a decorated disabled veteran, and I'm standing here on oxygen because of sacrifices that I made for our country, preserving our freedom, our right to be treated equal. And what do I get in return? It's very heartening, very saddening that I'm not being treated equal during this whole process. As Ms. Drake pointed out, all the irregularities. It's beyond frustrating. I felt humiliated, and I still feel humiliated that I had to go through all of this just to get approved. And we need to do better. We just need to do better. That's all I have to say.
Thank you.
Yeah, thanks.
Mr. Ewing, before you sit, all I can say first of all is thank you for your service. I know what that takes, and I know the sacrifices that are involved in that. And as a person, as a board, as a town, we thank you for that service. I can appreciate your frustration and even your anger. I certainly can. But again, it's like I said earlier, as far as the authority this board has and what's within our purview to control or decide on matters of any kind of reimbursement for legal fees or any other direct action as a result of this whole thing is certainly not within our purview. Those are things that would be taken up with the town or through some other means. There's just nothing that we can do about it, and I'm sorry about that. All we can offer is our apology for the delays and the expense you've had to incur, but that is really all we can do in that regard. Did you have any comments?
Yes, hi. Thank you for your service as well. Equality is very important in our world today. I can understand that. I don't think this is going to make me any friends, but as I've learned from doing my past ordinance work with past municipalities where I lived in California, is that ordinances and enforcement of those ordinances are only as strong as the definitions of the terms. I don't believe that there is a very strong definition for many terms. I looked and searched all through, finding the term for what an alley is really supposed to be, coming up with that 1987 Town Code 62.3, defining that what a public alley is. So I don't know, my suggestion, I mean, this is just my suggestion, is that the town, I feel like our town is growing substantially right now, and I feel like the town should devote a little bit of the budget to hire a dedicated attorney to maybe revise some of these terms and kind of be able to help our town with this growth and be able to enforce some of these ordinances, because the ordinances can't be enforced without definitions. Anyway, my conclusion is that I could not find that there is any support that this was a public alley. So I agree with our zoning administrator, her decision today, that this is not a public alley. If anything, it's a private alley, but that's completely up to those individuals. But that is the only thing I could find. So I'm in support of the zoning administrator's decision.
Mr. Elam, I'd like to also join in saying I'm sorry for what's happened to you. And there's probably about 100 million people in this country that should say they're sorry too. Katie, I had a question for you. Is there no provision anywhere for you to simply change your mind and say, well, you don't need to appeal. That's not my ruling anymore.
He has appealed. That is the case before you, so you need to take action on that appeal. And so, yes, I think you need to take a formal vote.
I mean, I have no problem with that. I'm just saying, it seems to me like
and I say
you
this
should be able to do
because
that.
we definitely heard testimony during the public hearing process from just about every property owner in this block of property. It's a 50-50 calling. 50% of the residents do not want the alley, 50% do want the alley. So I think there will be an appeal of any decision issued by this board into circuit court, which is allowed under the Code of Virginia. I have brought you copies of that section of the Code of Virginia just so you're familiar with it. It is section, and I just handed away all my copies so Bill can tell you the section of it.
It's section 15.2-2314.
Thank you. which gives everyone the right to continue going through the legal process if they so wish, and I feel that may be the case for other property owners in this area who may feel this decision is wrong. And all you're doing is I'm making a recommendation that I think my decision is now wrong when I factor in the town code, actions and ordinances that created a public alley definition and process. So I think you are the only ones who are empowered to now deal with
Right.
that and make
If
a
I may.
decision today.
I hear that we have a town attorney,
The
who-
town council has a town attorney, yes.
okay, who didn't feel inclined, I guess, to write a substantive letter or anything. I hope they're being paid by the hour, that's all I can say. Because other than a letterhead, I, you know, town attorney, what town attorney? You know, but at any rate, that's just,
Nor do we think you as the Board of Zoning Appeals need to have a town attorney attending to every decision that you issue from this dais. We
Every-
think you are quite competent and you've been selected by the town to represent
well,
in
this
these
would have been,
matters.
this would have been the first one, no, I mean, not
It
every.
doesn't mean in the future, so that if an appeal is filed on your decision today into circuit court, that will be brought to the attention of the town manager and the town council. And at that point, because service would be on the Board of Zoning Appeals of Cape Charles, I believe the town will step forward and a town attorney will be representing the Board of Zoning Appeals in that appeal into circuit court if one is filed.
Yeah, well, I don't know, we could debate about this, but one of the prime jobs of an attorney is to keep you out of situations like this. I don't think I have much else to say. I'm ready for whatever you guys want to do.
Well, I think we've reached the point that it's time to take the one and only action that we're empowered to take, that being whether we're going to uphold or not uphold the zoning administrator's decision. And based on her own words and what I think we've decided on our own from reading over 250 pages of total documentation, or reading 80% of it anyway, I'll say. There's been a lot of work done on both sides by everyone to kind of bring this to light and dig in a little deeper. And certainly if we've learned anything else from this, it's that there are a lot of controversies surrounding alleyways and the application of zoning ordinance versus town ordinance. Those are all things that will probably bear further looking at. But to bring it back to the central point, would someone like to propose a motion, and we will word it, you want to read the actual proposed motion or just summarize?
Sure. I'm happy to read it. So I am proposing that you motion to overturn the zoning administrator's zoning clearance decision dated January 24th, 2023 regarding 214 Washington Avenue and require a reconsideration of the zoning clearance application filed by Harvey and Angela Elam for the placement of a fence in the rear yard to be done only through the application of Cape Charles zoning ordinance section 4.2 G1, which does allow in residential areas for the placement of fences and walls no closer than 1 inch from adjacent property boundaries, since there is no public alley to be taken into consideration in this zoning review. And said motion is based upon the fact that the zoning administrator did not factor in the town code section 62.3, which defines public alleys as the acceptance of the platted and dedicated public alleyways as public alleys, and there is no evidence that the alley from Pine Street to Strawberry Street between Washington and Jefferson Avenue has been platted and dedicated as a public alley, and the information provided in the briefs from Attorney Drake and Eason do not show that this is a public alley. That is the motion I'm proposing for your consideration.
So I support that decision, that this is not considered a public alley, so
It's not my decision, it's your motion. It
Okay,
would
so
be your
I make a
decision.
motion,
You would make a motion to adopt it as.
I make a motion to adopt
Okay.
it as said by the zoning administrator.
Second?
Second. All right, all those in favor, aye?
Aye.
Okay, motion passes. The zoning administrator's decision in this particular case has been overturned.
And so again, I do want to stress for everyone here in attendance today that, as I've mentioned, there is a ability for this decision of yours now issued to be appealed by anyone who may have a party or an interest in this matter, 30 days from today's date that this can be appealed into circuit court. And so, yes, the statute I just put out to the board, and anybody who would like to have a copy of that may get it from my office, is available, and there's a process that you can file into circuit court. So we will hold off making any further action until the 30 days of appeal have run their course.
That was gonna be the last question I had. Because this is now overturned, does that automatically grant approval of the original request to place the fence, or is that held in advance pending a possible?
It will be held in abeyance for 30 days until the appeals period runs its course, and then at the end of that, if no appeal is filed, then we will automatically issue the zoning approval to the ELOMs. Yes.
Anyone else? Have any? Okay. If not, that takes care of that, and there is no new business pending at this time for the board. Are there any other matters that we need to, of any other matters?
No matters, and no applications have been filed for your July calendar, so we are going to cancel your July meeting.
All right, so the next meeting would be the second Tuesday in August,
Yes,
should we need one.
yes.
All right, if there are no further comments,
No.
we're adjourned.